of November 20.
Yeah, Joseph, you didn't receive anything yourselves, right, at CCSB or Farm Reports? That's what Barbara's asking. You only received the subpoena from Rich, which was the one Ren Farm got. Is that correct?
Right. We didn't. We can, of course. I think, but by now we haven't even Pharma Ports hasn't received anything related to this. No.
Yes, Joseph, do you mind checking with Pharmaport? Because according to what also the lawyer told me, everybody involved, so suppliers, drug products, and any agent must have probably received the subpoena because it's a broad antitrust lawsuit against the brand. So basically, he's saying that the brand, I'm trying to find, there are four different civil actions in regard to icosapenthyl. And so I'm reading actually all of them, even if we are not, and you will not be sued by anybody. So we are just called to provide information.
Okay, it's kind of sort of like a witness, something like that.
Not even witness, it's just providing information.
Okay.
And how they will use the information, obviously, we don't know. The problem that we are facing, that you may face as well if you get the subpoena or if you already receive the subpoena, is that they are requesting really a lot of information.
Okay.
So, for example, in regard to our communication with you, they are asking basically anything that was ever discussed in regard to icosapenthyl with any supplier or with any client or internally. So far,
they mentioned, sorry, Barbara, they mentioned specifically CCSB in that point too of definitions, right?
Yeah, we saw this CCSB, but I did not see like a Pharma Ports, or.
Joseph, I don't know. Barbara, it's really interesting because they mentioned RJW, which I found pretty odd. So somebody must have, I don't know. But Joseph's right. They didn't search CCSB enough. Oh wait, it does say in Farm Reports. In number 2, it says CCSB means, their name and Farm Reports.
Number 2.
Number 2 in definition, Schedule A. It's I think on page
Schedule
2. Page
A.
4. Page 4, Schedule A.
I saw Schedule A definitions, but I see in the point 2, I only see CCSB. You mean, or page 4?
And the Pharmaport.
Okay.
I missed that the first time. A few times I read it too, and it is there.
Okay.
Yeah, but Renee, it doesn't mean that they already got the subpoena. This is the subpoena to us that said we received the subpoena in regard to CCSB and Pharmaport, in regard to ICMA, in regard to the generic icosapenthyl. So that is the part that is personalized. So if it is a different agent that is supplying a different client, they will not have a CCSB name in there. They will have whatever is the supplier. But this means that, again, I'm a little bit surprised that you did not receive it yet. So if you received it, you probably received at Pharmaport. So if you can check on that. Because again, we are surprised that we received it, so we would expect that certainly you already received it.
Yeah, I mean, anyway, right after this talk with you, I will call our colleague in Pharma Ports. But anyhow, we haven't received anything, but for security, I called them to double check whether, before today they have received anything from the court or something related to this. Yes or no, we will anyway reconfirm to Barbara to you then today, so that you can at least have some clarity. But I don't think they have received anything, but we will double check it now.
So all the subpoena has to be given in person, so they cannot just send it via email. Because you received the subpoena They need the proof of being given. So must have been given to any employee who signed for receipt.
Yeah, okay.
You know, Barbara, the only thing is we got it a month ago on 10/20, so you would have thought they would go at the same time. But you know what also, it's saying that the attorney that sent the subpoena to us is Amarin's attorney. So is Amarin trying to get us to help them in their case against the antitrust?
Yeah, that I don't know. But going back to the conference, so Joseph, we will have to produce a lot of information that obviously will be also communication between you and us, or where we were in copy with the between you and Roxanne at that time, and the ICMA later.
Okay.
We will be using a lawyer that ICMA recommended to us. I will be talking to her today because it took some time to get the information or a final decision from ICMA. So this morning I will call the lawyer, because our intent is right now to limit the scope of the request.
Yeah.
Because it's very broad right now. So we will try to reduce from a timing standpoint to whatever is the case, and then also to the extent, like we want to limit it to the supply to ICMA and not any other potential discussion that we may have had with you and other potential clients.
Okay.
So the first attempt will be to see if we can object. Usually the objection is possible, but I obviously have to see what the lawyer is recommending from that standpoint. And the due date is November, which doesn't mean that is the date to provide the information. So the idea is to have at least sending the objection or an acknowledgement of receipt by November 20, which is Monday.
Okay. So at this time point, at least we don't need to supply a lot of information anyway. So we will anyway. I mean, we wait for your any further suggestion or instruction from the attorney. Then we will see, because actually we already sent this also to our company already. I mean, before CPHI already, but there's not much information, So we are just wondering what we should do,
Yeah, you don't have to do anything, because this subpoena is just to us.
Okay.
So the reason for the call is that obviously we are your agent, so we want to let you know that we will have to provide some information.
Okay.
And the problem is that we cannot, we have to provide everything. So we don't know what was in the communication, and we be the lawyer that have the ability to hide certain information if they consider them not relevant. But as if once we agree with the lawyer on what we have to provide, timing and documentation, they will get everything. But for you, there are no action item apart from, again, checking if you got the subpoena as well.
Yeah, I'm just afraid say something similar to PharmaPorts. Maybe we are not so experienced to have this kind of situation. Then anyway, we will check whether receive the same thing or not. Okay.
Perfect. And then I will also mention to the lawyer today that you didn't receive it, just to know if for her is normal that the subpoena received at different point in time, or just to see what her comment is on that, and I will let you know. But we should avoid any written comments or exchange. So also I'm the designee person at reference, so just communicate it to me.
Okay.
But again, every email, every message that I will be getting, if the subpoena cover that, I will have to provide it.
Okay. Yeah, anyway, this kind of information I will also remind our colleagues in PharmaPorts in, anytime, maybe later, or even they have received anything. Anyway, we discuss with you at first to give, before we give any information to other parties. I think that's we understand, and we will also keep them informed about the current situation. So far, we haven't informed my colleagues in Pharmaport because I didn't see that involved Pharmaport. But anyway, I will call them right after this talk. Okay.
Perfect. And the other thing is, oh my gosh, I skipped my, oh yeah, as far as what Renee was saying before about being covered by ICMA, unfortunately, the agreement, the standard type of agreement does not cover subpoenas like that, because basically ICMA is not has not been sued, so it's not a defendant, and the coverage will be only if we are sued.
Oh, okay.
So that will probably be the same for you. So if you have a similar agreement with your clients, probably you talk about what is the legal term, Renee?
Hold harmless?
No, indemnification.
Indemnification or hold harmless. Yeah, Joseph, I don't know if you remember way back, we were sued. Well, HICMA, Roxanne was sued for virilimus. It was Roxanne. I think it was Endo. I think also Breckenridge. You were supplying at the time. And what happened then is we called up Roxanne and we told them that we got a subpoena, because we did get a subpoena when they were sued, and they basically took over everything. They told us what to do, and and we sent the documents to them. They gave it to their lawyer, and obviously they covered any expenses of having a lawyer. And as Barbara was just saying, our supply agreement with HICMA for the supply of EPA, while it contains this hold harmless or indemnification, it doesn't cover us, or it doesn't say they will cover the expenses, legal fees, if we, Ren Farm, CCSB, get a subpoena. So Barbara, as she was saying, for the last few weeks has spoke with the HICMA attorney, their outside attorney. And Barbara, the last part of that discussion was what, yesterday, where you want to explain what they told you?
Yeah, so basically the indemnification cover any lawsuit against any of us. So if you are sued, or if you have to be called as a testimony for defending ICMA, you would be covered by the indemnification.
Okay.
But this type of subpoena are different because ICMA has not been accused, we have not been accused, you have not been accused. So it's just legal expenses in the cases in which they have to incur as well in legal expenses, but not because they are defendant. So the term indemnification does not cover that type of legal fee, because again they are not protecting us, because there is nothing to be protected. We have
however
however there are some expenses, and that's why with us they have been generous, because they admitted that we are just the agent, and they say since you supplied the thing, so they cover some expenses to a maximum. So has been good, but they said that they are not even obligated from that, because again it's not falling into that terminology. So in future, both the agreement between us and also you may change, because this antitrust lawsuit is becoming very frequently. In the last 2 months we already heard about 2 of them, and when I did, it's incredible. So it's basically is a civil action in which is basically the population. So there's this group that says that the generics, that the brand make agreement with the generic to avoid the entry of other generic in the market. So they are talking about the settlement during the paragraph 4 litigation. They are talking about the 180 days exclusivity, saying that in that 180 days, other generic cannot enter, and therefore they are suing the brand company or the generic company that got that exclusivity.
Okay.
Yeah, or Joseph, you remember how Apotex and Dr. Reddy sued Amarin, and then later Hikma sued Amarin, implying that they bought up or somehow try to take control of all the API supply.
I only remember that Dr. Reddy, but I didn't recall if Apotex or really did the same. Or okay.
It was Apotex as well, and then more recently, not recently, but maybe 9 months or something like that, Hikma, which we all were surprised that Hikma sued Amarin because we were supplying Hikma and we knew they were getting API, but at the time we couldn't supply them sufficient quantities, so I guess for whatever reason they decided to file as well. But Barbara, it's making me think also because CCSB is involved in this whole thing. Like we have to, hopefully we can say something to get out of it completely, and Joseph, that might work. Or we can say we want to limit it, that might work. But at the same time, a lot of what we're going to be supplying involves CCSB. So Barbara, you would almost think CCSB should want to have their, someone look at it on their behalf, even though I would guess if we use this Hikma lawyer recommendation, they would look for both of us. You know what I mean?
Yeah, unfortunately, we didn't think about the discussion with CSB until yesterday, so we were really considering that we needed to be protected by ICMA. In reality, the majority of the communication are with the CCSB. However, again, CCSB is the API provider. So the focus is always more on the drug product. But in future, we would call you immediately, and you may want us to be represented or to use your own lawyer, because probably 90% of the documentation is with you, and I don't know if there were discussion about the other API suppliers, so we have to be very careful in future also on how we write things, because we may have speculated about the entry of the market or move that somebody may do to limit the competition. Nowadays, all of that speculation could be used and construed against one of the parties. So I really didn't think about CCSB at that time. Otherwise, we would have had this discussion earlier.
Well, and Barbara, like Joseph said, it all happened when we were at CPHI, so we were all a bit distracted. Like we didn't even remember, Joseph, that Rich sent it to you, so I'm glad he did. But I guess when we got back from CPHI, we should have, discussed it then. But it kind of like took a back, or went on the back burner, as we say, until Barbara started contacting Hikma, and so now we're at this point.
But I'm reading right now one of the civil action, and it's very interesting because just to give you an idea, Joseph, on how this works, is saying a civil action number 12416 alleging Amarin violated state and federal antitrust laws by monopolizing and engaging in a conspiracy to restrain trade in the API market. Amarin is a defendant in a class action lawsuit filed by KPH Healthcare Services on behalf of direct purchasers. So, and Renee, KPH Healthcare is the same company that was involved in the other supplier.
That's interesting. Yeah, that's probably their main business now.
Yeah, they have been. I checked last time, and this is a company that has been created in 2016 specifically for civil action in the pharmaceutical industry.
Yeah. I mean, I guess we have to ask this lawyer. So, Joseph, what Barbara was saying is the way where we are right now is she spoke to Hikma's outside counsel yesterday. He explained that the paragraph, let's say, in our supplier agreement doesn't cover this. So, in that respect, we're going to be changing that and making sure in the future we word it with including everything. But anyway, aside from that, he said, however, because as Barbara mentioned, we recognize you're the agent, so, we're willing to help you out. We're willing to pay some minimal fees. So they are going to recommend, Barbara, it's another law firm, right, that we should contact?
Yeah, it's a different one.
So Joseph, they're going to recommend to us another lawyer who they're going to alert ahead of time, once we tell them we're agreeable to use that law firm, what the situation is, and that they'll pay for a certain amount, let's say, up until, you know, and that's probably the best because they know the whole case. And Barbara, I would think what we should just do is tell them that we reject the fact that we're even involved in something like that. I mean, we don't have any.
Well,
right?
Yeah, being the commercial agent, I think that is difficult to say that we have nothing to do with the antitrust because they will probably look at the movement. And again, if we say, yeah, we didn't sell to that client to facilitate Amarin. So, but I will see what, again, I'm calling her, so I already got the contact information, so I'm calling her this morning, and she has already been brought up to speed yesterday after I confirmed to the attorney, so I will definitely see what she recommended, but I don't think that we can object entirely, but definitely limit, because it's so wide that it would be crazy if we cannot limit.
Yeah, but for me, I mean, we understand that expense might occur, and just we of course we understand you are helping us here. But we're just wondering, even if this we were, I mean, Renfang or CCP was not really covered in the supply agreement, but in this situation, actually, this is quite like opposite to this paragraph 4 scenario because this is Hikma that raised this legal action to Amarin, so it's opposite, right? In paragraph 4, it's always originator that raised this legal action. So in this situation, I think can't we talk to Hikma even if before this we were not covered, but now we are your supplier in this situation. We are helping. Maybe I don't know. We are like a witness. We cannot help a plaintiff or defendant. I don't know the situation, but in this situation, can't we be covered from this action now? Because we are somehow even in paragraph 4 it's opposite. It's Hikma that raised the legal action. Even they should understand this situation and support us more rather than let CCSB or Renfang to take care of all this legal expense. That's my point. I feel a bit weird. I mean, this
Joseph,
is
that's exactly what Barbara and I discussed. Normally the customer would want to see what we're submitting. Would want to have control. I honestly, well, in a way, I guess the fact that they're telling us to use this specific lawyer, they will indirectly be involved. But Barbara, what's so interesting, this is a lawsuit against Amarin.
Yeah.
Exactly. That is my entire point. So
yeah.
That was, Joseph, I did exactly the same. I used exactly the same argument with ICMA, but then yesterday he really clarified. So it's true that we are not covered because they have not been sued. So they are not defendant. They received the subpoena as well, and they have to provide information as well, and they will object. So they said that they already objected as well on their part. They don't care at the end in what is in our documentation because they have not been accused of anything. So it's Amarin that has the lawsuit. So, and when I asked to be represented by them, so by this external lawyer, he said that it's better that we are not. Because the information that they are asking may include topics that have nothing to do with ICMA. So they said that we need to have somebody that look at our best interest, and they will not be able to block, ICMA will not be able to block any communication that has been requested. So they don't have to go in court and and explaining what the communication said, because this is just a subpoena. They have not been sued. We are not going to court He's just providing documentation for somebody else. So it's very different than a paragraph 4 litigation.
Right.
Yeah. Barbara, did they happen to mention to you, like, did they object 100%? And so for us, they could tell us that we object 100%.
No, he just said that they objected to, and they said that typically they always do. So he said, yeah, the objection is what do, and we did it as well. But I don't know also what they were asked to provide. He agreed that was an incredibly wide one. So they said, oh yeah, that is crazy.
Yeah, so I guess what we should do is ask this lawyer if we could first object 100% because we're not involved anyway with Amarin in any way whatsoever. We never talked to them, we never supplied them, so I would think that's what she should try first.
I don't know. We will see what she does. Again, these are common nowadays. These are common lawsuits. So we will.
So Joseph, just to let you know, another point, like you were saying, if for some reasons this turns into something we don't expect it to, but if it does, then we're going to have to like go to CCSB and say, look, as per our contract, CCSB is supposed to take responsibility for things like this. So probably in the meantime, you should definitely at least have your lawyer review this subpoena.
Yeah. We just don't know. We even not got sued. We will not. Then we have to already bear this legal expense. But we don't know. We this maybe American society. We in Taiwan is not like but we have to understand the situation. And definitely we in this situation we do have to also involve our attorney. He's also understand the how it works in the U.S. So we definitely have to have our attorney to understand the situation. So we just wanted to know that this implication to us, and as you said, that some expense might happen something, then we can have like more predictable for us. Otherwise, we don't really know what's going on there and why involve us, and no one can really in this situation. We were not plenty for. Then we already have to cover this expense. It's really for me. I still don't know how to explain to the management, or maybe our lawyer knows better than me. So I would discuss with them then to present this situation. Then I think if it is very like a common, I think we definitely can understand. Not so far, maybe I just don't have that experience to judge this is how this could happen, and the consequence, So that's something we will definitely next week maybe we discuss with our attorney, and we will have more clarity for this. But for now we understand this anyway the potential expense, and I also have to inform our colleagues in pharma ports at least have to inform them something they might have to be prepared for anything like this. Then I think we are good.
Yeah, and Joseph, just so you know, in the past, because we've gotten several subpoenas, but from lawsuits, this is like Barbara said, this type is fairly new, but in the past, they usually deliver it to the U.S. representative. So, for example, if Farm Report was called CCSB USA, they most likely, in fact, probably definitely would have gotten it. They just might not, whoever did this, might not have understood that CCSB actually has their own office, because some of our other suppliers have their own office, and where they did, those are the places that got subpoenas, not Ren Farm. But for our suppliers that did not have U.S. offices, it was Ren Farm who got the subpoenas. So, my guess is that they don't know about farm reports, even though, But no, wait, sorry, they mentioned it, though, in point 2.
They mentioned, but if you remember, Renee, the other case, so with the other supplier, they got subpoena, but nobody at the U.S. offices realized that was a subpoena. So nothing was done with the documentation, or maybe it was never delivered. So Joseph, for now, I would not worry too much about it, because right now you according to your knowledge, you have not received anything.
No.
If you receive, remember that you don't have to defend yourself, you don't have to defend us, or you don't have to defend ICMA. You will just have to decide if you need to to reduce the amount of information that they will be asking.
Okay.
And that's all. The expenses, I will know a little bit more today, how much it is. I will try to limit as much as possible my call with the lawyer. So I will ask the least amount of questions because everything is by minute with the lawyers. But you will not, it's just a matter of providing documentation. They can also submit it without reading if we want.
Okay.
Because we don't even know what they will be doing with the information that we provide. And I will let you know, but again, we will have to do it via phone call. Again, I will not write a summary via email.
Yeah, I mean, because Barbara, the other thing, when you think about it, we're responding as CCSB's representative. I mean, if it was the other way, if I was CCSB and somebody was responding based on my business, I'd want to see what they're submitting. I wouldn't want,
But not really, because they are not defending anything. So if right now, if 15 years ago, we talk with another supplier about EPA, we have to provide that information as well. Because they are not asking communication only in reference to CCSB supply to ICMA. They're just saying any information about IPA.
Right, except they're going point by point because they're saying all communication with any supplier, then all documents related to manufacture and supply, and then all documents related to any actual business between HICMA and CCSB or Roxanne and CCSB.
Yeah, but then also everything else. And
right.
Again, even if CCSB was being accused of something, absolutely, they need to see the communication, and they will be prepared to discuss the communication in court.
Another thing I'm thinking right now,
it says
others. So technically, we should be providing everything within TEVA, including TEVA, our communications with TEVA and EPA.
Exactly. That is why it's so crazy.
But do we then notify TEVA that we've been subpoenaed?
No, because they are not being accused. We just received a subpoena where it says, reaffirm, you have to give us everything in reference to this product.
Right, but think about that.
It doesn't matter if TEVA received it or not. TEVA is not being accused. They are not on the table with the judge in which they have to defend themselves.
Right.
Maybe they will in the future, who knows? But right now, it's not. So no, I would not inform them. We inform ICMA because we wanted the expenses to be paid by ICMA, and then just as a courtesy because they are really our source, our client. Yeah.
All right, you know what? We have to go step by step, right? Because I feel uncomfortable if they ever came and said you need to do it with every customer. So sending to some legal entity our correspondence with TEVA and not alerting them ahead of time that we've been subpoenaed by this organization asking us for all information, just as for their information, I would think they'd want to know. I mean, again, maybe they also got one and they haven't come to us. I mean, this one is only saying HICMA, or it does say everybody.
Exactly.
So
they did, and we didn't receive any notification because they are just providing the information. So they are not saying that we are their defendant. They have not been accused.
Right. Okay, so I guess in summary, we're going to ask the lawyer, the first step is to just reject the whole thing and see what she says, right? Because we have no impact on Amaranth. And then the next step, Barbara, will be to ask to limit communications to what? Or to ask her what we can limit it to?
I have to talk to her.
Okay.
Yeah.
And then Joseph will let you know, or we just schedule
Okay.
a call for next week. Once we know and have a clear picture of the suggestions from the lawyer, if we may not get it today. She might want to read it. Barbara, do you happen to know if did he say they sent it to her? No, right?
He already got it, and she already knows that I'm calling her this morning. Yeah.
Right, but he did send a subpoena to her?
Yeah. Yeah.
Oh,
he
okay.
did.
Okay.
He did. Sorry. Yeah.
Okay. All right, yeah, Joseph, either we'll find out something today, or I don't know if this lawyer's going to say she wants some time to, whatever, and we'll know Monday. Once we do have anything, we'll let you know.
Okay. Okay.
Because obviously, we're like you. We don't want to get into having to use a lawyer and pay exorbitant legal fees for something that, no one wants that.
Yeah.
And as we said earlier, I mean, HICMA said they would cover us up to $50,000 of expenses. So hopefully it doesn't reach that, because anything over that, we have to go to CCSB. But again, let's go one step at a time. Let's just see what the lawyer says. And yeah, Barbara, you'll ask her how they're going to bill us or whatever. Or I don't even know if you need to ask that right now. First, we have to just find out what they're going to do, right? Yeah. And get an estimate of the cost for her to do that.
Yeah, I will ask how many hours does this typically take, if it is based on the amount of documentation that at the end they agreed, and then what is the how do they charge, if it is by hour, if it is by, I don't know, a fixed fee, or however. I think that is by hour, but I will ask.
Yeah, because the way it's written now, you're talking about 1,000 pages probably. If they're really looking for every single document, which we started this, Barbara, you were at HICMA. I mean, we started this probably 10 years ago.
It will be much more, because if in your email you copy Scott, Mariana, me, and other people, everybody has to provide that information, unless it is given electronically. But then they are asking a picture, so if we have a drug master file from CCSB right now, we have to provide that as well, because it says any document related to the product. Email, databases, so databases, for example, will be the any database where we have the name EPA. That's why the request right now is crazy. This will be one room full of documents